Okay, everybody. My name is Patrick Johnson. If you don't know me, here is Corey Meaux, another partner here at the firm of Parker Landry. If you're not familiar with what this process is, it's something that we created a few months ago, and it's a monthly thing that we do. And you'll get a notice a month in advance if you're on our email thread, and it'll give you the team's information. Basically, what we're trying to do is most of you get those 3-hour CE trainings from different defense firms. Okay? That teaches you the law. Then, what is that in the camera? Okay, well, that was someone else. So you get a 3-hour CE training and you learn the basics of the law. Then you have those attorneys you're comfortable with calling, I have a question, or sending an email. But everything in between is left to you learning on your own in a state that is very penalty and attorney's fee, shall we say, generous. So this is a way that one of the many ways that we can use to try and prevent you from having to learn painful lessons on your own when it is usually learned in multiples of 2 of the penalty. So we have the email class. We have these presentations. We have books. We are actually offering the same type of program in a different manner to insurers. So we are going to make everybody better because otherwise relying upon things to change on their own hasn't worked for the past 30 years. So if you caught the last two, we had Judge Pam Larimore in February. March was Alan Jordan to talk about mediations, which actually one adjuster already used what he taught her to achieve a good settlement. Sorry, an adjuster used it. Today, we're moving into the actual practical trainings. So we're going to talk about recorded interviews and tips to improve it, because I think a problem that attorneys have and that we have is that we have gotten in the habit of telling adjusters over the years that what you have in your recorded interview isn't useful or isn't effective. It's not as strong as you think. Well, that's not entirely correct. The questions may be vague. What you think they said is not what appears on that particular transcript. And so instead of asking you to do better, we are going to show you how to do better. Every one of these tips comes from either how both of us learned how to take a deposition or arise from actual cases where reliance upon a recorded interview resulted in a penalty being awarded. Spot a problem, fix a problem, share it with everybody so no one has to encounter that again. That's the goal. Okay. We do want to thank, obviously, Dave and Brenda, because see, we have outlines just like everybody else. And there's a reason why we have this. So we've talked about why these are important, or why they're a problem. But what makes a recorded interview important? It's odd, but medically speaking, and I'm pretty sure someone could do a master's thesis on this. When a person has a work-related accident, it actually forces their memory to get better over time. Their memory will improve over time. But that's because we never force them into one particular story and force them to stay there. And that's the benefit of the recorded interview. Within 28, 48, 96 hours, whenever your policies require that you take the recorded interview, you can lock them into a story. Okay, if you get enough detail, they can't wiggle out of themselves later or with the assistance of their attorney. You lock them in early and it prevents them from expanding, because what they don't know at the recorded interview, if you don't frame them into a story, they are going to change their story in time to make it do away with all the problems. So you lock them in early. Okay? You want the raw, unpolished version of the story. You have to lock them in, and it prevents it from changing later. And that's what the recorded interview is. It's both getting factual information that allows you to direct your adjusting of the claim, but as to how we use it, and you as well, is to lock them into a story. Because it will change over time. Every one of you has seen it before. The left becomes a right. No witnesses becomes two witnesses. It was originally my back, and now it's my back and my neck. Because you did not lock them into a cage early on.
Yeah, and then going on that, the biggest issue I've seen, and Patrick too, is really the word usage in the recorded interview and getting too technical. It's hard for us. I mean, we do this every day. You do it every day from an adjuster side of things, and we do it every day from a legal side of things. And so you've got to remember that a lot of times you're dealing with uneducated people. You're dealing with people in the oil field and retail, and they just don't understand language that we know. They don't know, indemnity. They don't know a workers' comp claim. They don't know what these things mean. And so it's really important to, quote unquote, dumb down your language. So whenever you're asking them, if you want to know whether they've ever had prior claims, don't say, have you ever had a prior workers' compensation claim? No. Have you ever been injured on the job before? Have you ever hurt yourself on a job while working with anyone? Have you ever felt pain at all while working to where you had to talk to HR or you had to talk to your safety guy? Those are the things you're going to ask. Don't ask, did you ever receive prior indemnity benefits? No. Did you ever receive money from your company outside of your normal paycheck because of an accident? Did the employer ever give you checks or pay for medical treatment because of a prior claim? Those are the things you want to ask them. And my biggest thing that I've seen before is, have you ever injured your lumbar spine before? Okay, I'm sorry. I don't know if I knew what a lumbar spine was before I started really doing this or getting into this. Did you ever hurt your back? Did you ever complain to your doctor about a back? Have you ever gone to a chiropractor? Have you ever gone to a physical therapist? Have you ever told your doctor, I wake up in the morning with aches in my back? Have you ever gotten an x-ray of your back? Those are the questions you want to ask, because it's going to be hard for them to come back and say, well, I didn't understand the meaning of, lumbar spine. Well, if you're saying back and you're asking them all these different types of questions in your recorded interview, it's hard for them to come back. We do it in our depositions. I will ask 9 different ways for prior injuries to the back or the neck or the shoulder or the knee, whatever it is. That way, if we go to trial on potential fraud, they can't look the judge in the eye and say, well, he said, had I ever injured my back, and I thought he meant an injury in the sense of, I like had to have surgery on it. Well, I can turn back and say, I did ask you if you ever went to a doctor and had complaints of back pain. I did ask you, have you ever gotten that back x-ray? So those are the things that you want to really focus on in your recorded interviews. Basically, act like you're talking to a 6th grader or a 6-year-old. You want to get across to them in such a, like you said, an unpolished, raw way. Just ask the questions like they have no idea what you're asking. That's going to go a really, really long way rather than using legal or medical terms.
Yeah, and injury, they will tell you later on in a deposition, well, I thought you meant an accident. So don't use injury. Have you ever hurt yourself? Imagine you're taking a recorded interview of, say, your 90-year-old grandparent or a 6-year-old. You go to the most basic way that the question can be asked and still be understandable. Okay, your supervisor is not going to go, why did you use such unprofessional or legal terms? Because I want to get the information. Okay.
And with that too, so like Patrick said, we have a script here. It's a little outline of what we're going to talk about. But I have one for every depo I take of both a doctor and a claimant. I have added to that probably every other month. Something comes up, I read another lawyer's deposition transcript. I'm in the middle of asking questions and something pops up, I'll make a note in my thing. I'll come back and I'll add it to my outline. Do the same thing with your recorded interview outlines. You know, when something comes up, add to it. And then email your whole group, email your entire workers' comp team and say, hey, look, this came up in my recorded interview. Just thought you guys would know we should maybe start asking these questions across the board. I mean, share with each other the issues that you get. That way, in the future, everyone is asking the same type of questions, but also learning from the questions they ask and building on those.
Yeah, and you don't want questions. If you're new to this, you may actually have questions, an outline of questions. Even new attorneys have an outline of questions. In time, you just have bullet points of topic areas.
Yeah.
Because you let the answers are what drive a recorded interview, like a deposition. Okay, you follow the answers all the way through. You get what you need. You've asked everything. Then you go back to the script. Okay, you go all the way through, get everything answered, and back to the script.
Yeah, always, never, ever, ever only look at your outline. You want to use that as your first source, but listen to what they're answering. You know, make sure when they answer the question, oh yeah, I went to a doctor about 10 years ago, and I think he did an x-ray of my back. Okay, don't move on. Stick to that and say, okay, what doctor did you see? Do you remember his name? Why did you have to get the x-ray? Do you remember what the x-ray results came back as? Did you have to go get treatment after that x-ray? Did he give you any medications for that? What was the reason for injuring your back? Okay, once you then build on that and you're like, I'm satisfied, I understand what it was, then you go back to your script. The answer should always, always dictate where you go in your recorded interview, not your script. Your script is there for a backup to review after and make sure you caught everything.
Yeah.
But the answers dictate what you're going to ask.
Yeah. So how we're going to do this is roughly, in a way, how we approach a deposition. So I'm going to cover the initial preparatory language, and I'll tell you why that's important, and the initial demographic information. Corey is going to cover how you handle the accident and how you handle the treatment, the claim side of it. Then I'm going to come back and pick up on the background information, history, medicals, things like that. Now you can do this any way you want, but always start with the information I'm going to tell you first. Look, I have taken enough depositions and read enough interviews. You are going to see commonly, oh, that question, I didn't understand it at the time. Oh, the medication was affecting my ability to understand your question. No, the court reporter wrote, I meant, as a no. She wrote, as a yes. Oh no, that answer, that was to that question, not the other question. So you've got to remove all of those potential defenses from the game board. You take them off the table. Okay. Good morning, Mr. Jones. I'm going to be taking your recorded interview, and I may slip into deposition, but you know where I'm going with this. So can I please get your full name, maiden name, if you have one, including junior, senior, what have you. Okay, I'm going to be taking your recorded interview today. The first thing I need to know is, have you taken any medication today? Yes. What have you taken? You don't need necessarily specific names. You want to know the types. Okay, pain medication. Okay. And high blood pressure medication. Okay, Mr. Jones. So you've taken those medications for a while? Yeah. So you know how they affect you? Yes. So knowing how they affect you, do you think you can participate in this recorded interview today? Meaning, can you understand my questions and answer? Yeah, I think so. Now, off the table is the defense later. Well, the medication was affecting well, I'll usually go one step farther. Mr. Jones, if at any point in the deposition you feel that the medication is preventing you from understanding my questions or providing an answer, I need you to tell me, and we will stop this recorded interview. And we will pick it up at another day. We will pick it up. And that's sort of a little encouragement to, let's just get through this thing now. But if they come back later, you offered to pick it up another day, and they did not say, oh, the medication was affecting my ability to understand your questions. You take it off the table. Okay, what if they say, oh, well, I started taking pain medication yesterday from the doctor. I don't know how it affects me. Okay, if you think it starts to make it difficult to understand my questions, you let me know. Okay, we will stop, but we will pick up again shortly. That is now off the table. If you do not do that, oh, well, the medication was affecting my ability to answer my questions or understand her questions, and I thought I had to go through it today. And everything they say, the court is going to put a big question mark over it. Because there's the argument that the medication was affecting his ability to understand. Okay. Then you move on. Now, if at any point during this recorded interview, I need you to give me a yes, a no, or take all the time you need to explain. No uh-uhs, no uh-huhs, because whoever transcribes this or puts this into a script, they're not going to know if you meant yes or no. So you need a yes or no or explain. Okay. Now, if in a recorded interview you get a question, ask him, Mr. Jones, was that a yes or a no? No. Okay. Did he answer the original question with the no, or did he answer your question asking if it was a yes or no? If you have to ask him, is that a yes or a no? You ask the entire question again. You want that new question and then the proper answer. Okay. Just ask it again. Don't assume you can connect the dots because the court may not agree with you. Ask it again. Okay. Also, if at any point in the deposition or at any point, I need you to allow me to finish my question before you answer, and I'll allow you to answer or finish your answer before I move on to my next question. If you are not done with your answer, let me know and I will stop my question, because we don't want us to be talking over each other, because whoever transcribes this recorded interview may make a mistake. Okay, you want a nice, clean, as we call it, a record. Then here is the single most important question you will ask in a recorded interview and in a deposition. Our instruction, Mr. Jones, at any point, if I ask a question and you do not understand it, it is not clear, and you do not understand what I'm asking, you need to let me know, and I will ask this question again until it is clear. If not, if you answer the question, we are going to assume you understood that question and answered appropriately. This is now off of the table. Well, I didn't understand the question. Your Honor, the adjuster gave him an admonition that he needed to let her know, and he said yes, he would let her know if he didn't understand the question. And the court may go, yep, that's true. So you don't now, a year and a half later, at trial, get to argue you didn't understand the question. That was your opportunity. Okay. This is in every deposition. You take all those off the table. Okay. Also, you want broad questions. I know it's sometimes, I'll hurt my back. Okay. Upper back, middle back, lower back, lower back. Your mind may think, okay, I've only got one body part. No, you need to know what else. Anything else. Anything else. That some will occasionally be stupid enough to give you 15 body parts from a lifting accident. What have you done? You now can attack the credibility because they've added 15 body parts. And every time they say a body part is related, you may have a potential fraud if you find out prior treatment that they later deny. Always follow it out. Anything else, anything else, anything else, until they stop. You don't stop. They stop. Okay. Now, you also want, I'm sorry, I jumped ahead into Corey's section, but for demographics, you want full name. You want present address. You do not necessarily need the address of the 15 places they lived before, but you need cities and towns, because we may go and get records in time from that location. If all you get is he presently lives in New Orleans, has he lived there his entire life? Or has he lived there for 6 months and the rest of the time he lived in Shreveport? Well, I'm going to want to look at Shreveport records as well. So you've got to get that information. You also want to get spouses' names, children's names. Do the children have any learning disabilities or physical disabilities? That's especially important when you're dealing with a death claim, okay? Because that's an issue. So you have to remove from the table what they are going to claim later. They didn't understand. The meds affect their ability to answer the question. They meant as a yes, and you thought as a no, or you did not go back and catch that question. Always do this up front. How you do everything else is your call, but always do that up front. And now Corey will pick up at roughly the accident portion.
Before I get started there, just another thing on demographics that you may want to add in there that I add in on my depositions is the make, model, color, year of any vehicle they own. And the reason for that is we can use that for surveillance. When these investigators are going out there, if, yes, we have pictures of them, we may have their ID, but if we have their ID and a vehicle, it's going to help that investigator get them a lot quicker. So that's just something to add in there when it comes to demographics. Any identifiable information that we may be able to use later is always a good idea. And it's real easy. Do you drive any vehicles? Yes, I have 2 vehicles. Well, one's in my wife's name. Okay. Can you give me the year, make, model, and color of all the vehicles that you and or your wife may drive? Done. That easy. Then just move on.
Yeah. Also, as you know, a recorded interview is not under oath. So there was always the argument, oh, that wasn't me taking the deposition. That was my brother, because I'm not comfortable with that kind of interview. So always ask him, do you have a copy of your driver's license? Yes, I do. What's your driver's license number? What's the address on there? What color shirt are you wearing? Okay. Because that is an argument that, Your Honor, he had his driver's license in front of him. Does it satisfy the same level that under oath? No, but it takes away a potential argument. Your Honor, he had his driver's license, he had his driver's license number, he knew what color shirt he was. Fairly likely that was him on the other side of that line, Your Honor. Take that argument off the table. Sorry, it's all you know.
Okay, so for accident, like Patrick said, broad questions. The way I like to do it and what may work for you is the first I go specifics, then I go to a broad question and let them talk. So the first thing I'm going to ask when it comes to the accident is, okay, what time did the accident occur? A lot of times they're going to say, I don't remember the exact time. Okay, well, how long were you into your shift? If you start your shift at 7, that's just a chat.
Okay, well,
yeah, we forgot to say that. If you have any questions, add into the chat. We're going to leave about 10-15 minutes at the end and go over any of those questions.
And real quick, Adeline, all I would say to that is I don't really know. I'm just working from a script of questions I have to ask. Okay.
Yeah.
You don't really know. Okay. But you're working from a script. So they will probably go, oh, okay.
Yeah. Simple as that. Okay. So yeah. So they may say, well, I don't know the exact time. Okay. Well, what time does your shift typically start? 7 a.m. Okay. How long into the shift was it? It was definitely before lunch. So I want to say maybe like 2 hours into my shift. Okay, you've now narrowed them down into at least the morning, and you got them about 2 hours. Some of them may remember. Some of them may say, oh, it was about 9:30, somewhere between 9:30 and 10. So that's my first question. Then I'm going to ask them, okay, what were you doing immediately before the accident happened? Then they're going to go back into their memory bank and start bringing, oh, well, I was pushing this cart back behind, blah, 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 just getting to what they were doing. So now, not only have you got them under the time area, you've got them in a part of the building, you've got them doing certain job duties, and that's going to help with, you got to remember, some places, I have some clients where there's cameras everywhere. These retail shops, they're going to have cameras all over. So that's also going to help us look and see if we have footage of the accident. Because you have to remember, a lot of these places, the video is gonna reloop itself every week or so, maybe every other week. So you're limited in trying to get footage of an accident after it occurs. So if you talk to them 48 hours after, you want to figure out where the accident happened or what they were doing before. Then you can compare that to any video evidence you can get. So, okay, after I ask those questions, my next question is, okay, tell me in your own words what happened when it comes to the accident, and let them talk. Do not interrupt them. Just let them talk. It could be a 15-minute dialogue as to what happened, but the whole time take notes. So, well, okay, so yeah, I was pushing this cart and the cart hit this little gap in the thing. I fell forward over the cart and flipped over the cart. Then after I flipped, I ended up hitting my head and rolled over on my side. And immediately after that, I remember getting up. I was dazed. My neck was feeling a little weird, and my right shoulder was feeling weird. Then I had some supervisors come, or one of my coworkers actually heard it, and a supervisor ended up coming, and that's when I went to the paperwork. Okay, so you're taking notes the whole time. So then I'm going to ask them, okay, let's go back to this. I just want, and you can say, I just want to make sure I have it clear. So I'm going to start back at square one, and we're just going to work our way through. Okay, so you said you were you were pushing the cart and it hit something. What did it hit? So then they can answer that question. Okay, well, there was this little gap in the back. I guess a piece of the flooring kind of broke off or whatever. Okay, well, how big was the gap? Is the gap still there? Do you know? Had you seen the gap before? Was it a thick gap? What part of the cart hit it? You know, things like that. Add into your answers and start getting there from just the cart will hit a piece of flooring. Okay, you then mentioned you flipped over the cart. Yeah, okay. Can you describe how you flipped over that cart? Did you go forward? Did you flip over handlebars? Did you go to the left? Was there anything on the cart that you hit? Blah, 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 stuff like that. Okay, you flipped over the cart. What was the first part of your body that hit the ground? Was it your head? Was it your neck? Was it your shoulder? And okay, you rolled over on your right side, you said? Okay. Did you roll over fully? Did you completely flip over the cart, then flip over again? When did you first start feeling pain? Was it your, he may say, well, immediately it was my head. That was the first thing that hit the floor. But then because of my head hitting the floor, I felt a little pinch in the back of my neck going into my shoulder. Okay, now what that tells you is if they felt neck pain going into their shoulder, chances are it's a neck claim, not so much a shoulder claim. You don't know that yet, but you're getting into those intricacies of a claim where you may have cervical pain with radiculopathy into the shoulder rather than a shoulder rotator cuff tear. And so, okay, well, you mentioned a coworker earlier. What's the coworker's name? John Smith. Okay, how long have you worked with John? Do you typically work in the same area? Has he worked with the store long? How long did he actually see the accident happen, or did you scream and he walked up afterward? Now you're getting into potential witnesses versus non-witnessed accidents, which is, as you know, is going to change the burden of proof they have to put. Okay, what did you and John talk about whenever he got there? Oh, well, I told him what happened. I flipped over. He saw me rubbing my neck a little bit. He asked me if I needed some ice. He asked me if I wanted water. And that's when the supervisor came. Okay, so the supervisor came in. Did you call the supervisor? Did John call him, or did the supervisor see the accident happen? No, John ended up radioing him on the walkie-talkie. Okay, what was the supervisor's name? Supervisor name was Jason Smith. Okay, is Jason your direct supervisor? What does Jason do at the store or at the work job? How long have you worked with Jason? Has Jason been there long? So now you're starting to get into the witness of the accident, the first person that walked up with regards to when the accident occurred. Those are the two people you're going to want to talk to after this recorded interview and see if their stories are the same as the claimant's stories. So once you did the paperwork, what happened next? Well, they asked me if I wanted to if I wanted to call an ambulance, but I told them I would just go to the doctor myself. Okay, so You didn't feel that you needed to call an ambulance. You weren't that injured. Nah, it hurt, but I knew I didn't need to get in an ambulance or anything. I didn't want to, waste their time or anything. So I just went to the Ahmed clinic. Okay. What Ahmed clinic did you go to? I went to the one that they tell us to go to, whatever. Okay. So now, the first medical report that you're going to go after is going to be that Ahmed clinic. So now you've got the witness, the supervisor, what happened immediately after the accident, and then the Ahmed clinic that they went to. Okay, when you arrived to the Ahmed clinic, was there anybody there with you? Yes, my supervisor, Jason Smith, came with me. Okay, was he in the actual examination room with you, or did he wait in the waiting room? Either way, you're going to go with questions based on that. And if Jason was the supervisor's in the waiting room, you now can talk to them again to see if it jives with the claimant's version of the medical that went on. Okay, what did you and the doctor talk about whenever you got there? Or did you see a nurse first? Well, I saw the intake nurse. Okay, what did you talk about? Well, I told them that what happened, that I flipped over the cord and that my head was hurting, my neck was hurting, and I felt some pain in my shoulder. Okay, let me ask you this. Other than your head, your neck, and your shoulder, did you have pain anywhere else in your body? No, I mean the pain in the pain from my neck into my shoulder was maybe going down in my bicep, but that was it. Okay, so you didn't have any pain on your left side? No. Did you have any pain in your back? No. Did you have any pain in your legs? No. So okay, like Patrick said, you have now cornered them into a claim dealing with the head and the neck for sure, with possible radiculopathy going into the shoulder versus a shoulder complaint. So now going forward, if later on, after reviewing the medical records too, all of a sudden, 3 months later, they start complaining about lower back pain, and no, we're not gonna deem that compensable, because immediately after I asked them, the medical records indicate it was only head and neck with possible shoulder. So now you're starting to get into body parts that aren't related versus related, and potential fraud claims there, obviously, but that's what you're doing. So I'm not going to go into treatment after treatment, but you get the idea. If maybe they went to, after the Ahmed clinic, maybe they went to their PCP. Afterwards, you're going to ask the same question. But with that doctor, ask them, what did you talk about? What were your complaints? Did the doctor give you any diagnosis? And if they say, what do you mean? Well, did the doctor tell you what was wrong with you? Ask again, language like that. They may not know diagnosis, but what did the doctor say was wrong? Well, he had mentioned something after the x-ray. He saw something weird in my neck, like he mentioned the word disc. Okay, now you know possibly there's a disc issue. Did he give you any medications? She mentioned an x-ray. Did they do any x-rays of your head? Yeah, they also did them on my head. Did they do anything? Do you remember the word CT scan? Do you remember MRI? Did they tell you to go see anyone else? Did they, other than medications, did they give you anything else? Any other treatment? Did they send you to a physical therapist? So you're going with those questions. Then you come back to your script and you start going into more and more of the background after the fact. And that's what Patrick's going to pick up on. So now you've limited to you've got the head, the neck, and the shoulder. And from then you can go back to your script and go into more history of their background.
Yeah. And so, like I said, and I'm sorry for all the notes, but anyone who knows me knows I can't turn my brain off. So I want to make sure all this is clear. You got to make, I used to use the word prior. Did you have any complaints prior to your accident? Then I thought to myself, no, prior, they may not know prior. Before your accident. Okay. So always reconsider and tweak your script. So medical history, you had what? Shoulder, neck, and
head, shoulder, neck.
Head, shoulder, neck. Okay. You're going to want to know who their primary care physician is. Don't say PCP. Maybe not even primary care physician. Who's your family doctor? I don't have one. Well, where do you go for complaints? Back pain, head pain. Where do you go? Flu shots. Oh, I go to the hospital. Which hospital? The one downtown. Okay, well, if you're talking about New Orleans, well, there's more than one. Which one? Okay, they should know. And if they're vague, that should be a red flag.
But just real quick, we're post-COVID. So what I've been using is, let me ask you this. If you don't have a primary care or family doctor, where would you go if you think you had COVID and you wanted to go get a test? That is an easy way for them to say, oh, well, for that, I want to go into the so-and-so walk-in clinic down the road. Is that where you normally go? Yeah, that's where I go anytime I'm feeling a little down. Boom, you got it. You can subpoena those records.
See, I never thought to ask that, and I like that question. So I may start using it. So you want to know the family doctor, where they treat, okay? If they're female, I know you're going to want to know their OBGYN, because some females will use the OBGYN as a family, a primary care physician, where they have their kids. You're going to want to know all that, because that's what you give to us, so we can use in discovery. Are you, if you have a claimant who's stupid enough to give you a HIPAA form and not designated, it's only applicable to one provider, and you go crazy with that. Now, you're also going to want to know their work history. So where did you work before the employer? What did you do? Where did you work? Why did you leave? How much did you make? And you want to know their work history, because if they give you 5 employers going back 10 years and you do an ISO index search, however you call it, and they fail to mention one of those, an employer that shows up in a prior compensation claim in that same time period, yeah, that's something you're going to want to dig up into. I had that. He went back 10 years with his employers, and the one he mentioned is the one that showed up in an index search 3 years before our accident, where he had a prior claim. So you're going to want to know their work history, okay? What if they work heavy manual labor jobs and you get an MRI where there are a lot of degenerative conditions? You're going to want to know that, because if they were able to perform heavy manual labor jobs before the accident with you, they may be able to take advantage of the presumption of causation and the presumption of disability. I could do those jobs in the past with these degenerative conditions. Now I had an accident and now I can't. Courts tend to forget that you hired a mouthpiece doctor to tell you what you wanted him to say. Medicals. You want to know as much about their medical history as they do, and more. So here's how I go about it. Mr. Jones, so you mentioned that in your mind, as a result of the accident, you hurt your head, your shoulder, and your back. I'm sorry, and your neck. Yes. And anything else that as you sit here, you think, oh, well, that was hurt because of that incident. No, so just those 3 body parts: head, neck, and shoulder. Yes. I just got him to confirm that twice, by the way, by asking it in such a fashion. Okay, Mr. Jones, I'm going to ask one body part, ask you a couple of questions, move on to another body part, ask you a couple of questions, and then move on to another body part. Okay, is that real clear? Yes, sir. I only want to know questions related to before you push that cart at work. Okay, only backwards in time, nothing afterwards. Is that clear? Yes. And every little slip, every little slice, every little instruction, you get that. Yes, I understand. Okay. Are we clear? Yes. So before your accident with the cart, did you ever have any problem or complaints with your head? Broad. No. Okay, so you never went to a doctor or a clinic, and Mr. Jones, whenever I say doctor or clinic, don't limit it, okay? I mean, emergency room, walk-in clinic, doctor, nurse practitioner, chiropractor, friend who knows somebody who works at a doctor's office, okay? You don't limit. If you even suspect it may be someone who qualifies, you mentioned yes, okay? Okay, well, let me ask that question again, just in case I wasn't clear. Did you see any healthcare person before the accident for any problems with your head? No. None at all? None at all. Okay. Did they ever perform, did anyone, and yes, I know you never went to a doctor, as you said, right? No, I never did. Okay, did anyone ever perform any tests or studies on your head? Like put you in a machine, under a machine, or next to a machine? No. Okay. You don't stop at I never saw a doctor. You go one step further. Did you ever have any medical tests or studies? Okay. That's an additional lie if it comes to that. And you would ask that for every body part. Now, what if he says, oh yeah, I did. Okay. So tell me about those prior visits, those prior complaints. Or then you flesh it out. What if they say, well, of course I had prior, neck problems. Okay. Like from work? Well, yeah, from work and from just doing stuff around the house. Okay. Was the pain ever bad enough that you went to go see a doctor or some kind of person to provide medical advice? Yeah. Well, who'd you go see? You want to know. If they give you a little information, you've got to follow it all the way through. You want that. If they give you a no answer, get a little more. Don't just take a single no and move on. You want a no and a no and a no and a no and a no. Because what do you have? You have 4 potential lies, not just one. Okay. Every body part. Okay. So once you tie down their medical history, okay, and you have locked them in, you need to go a little bit step further. Okay. Have you ever had any surgeries of any type? Okay. No or yes, flesh it out. Where do you get your prescriptions filled? Earlier in the recorded interview, you mentioned that you took high cholesterol medicine. Where did you get that filled? Oh, Walgreens. Yeah. Has it always been Walgreens? Like, let's say in the past 5 years, has it always been Walgreens? Yeah. Well, that you can give us. He only said Walgreens. Now, I'm going to subpoena Walgreens, Walmart, CVS, everybody.
Yeah.
Well, if I get other records showing prescriptions at a CVS or a Walmart, well, that's a credibility attack. Even if it doesn't give you fraud, and I know that that's everybody's goal. Fraud is fun, let's be honest. But it also is a credibility attack. Well, let's say we're talking. Mr. Jones, do you remember the court recorded interview that you gave to the adjuster? Yes. You remember she asked you to answer the questions? Yes. And she told you if you didn't understand the question that you could tell her and she would ask it again till it's clear? Yeah. And she asked you if you ever used any other pharmacies other than Walgreens. And do you remember what you said? No, I don't remember. Your Honor, may I approach? Mr. Jones, can you read that question? Have you ever used any other pharmacies? And your answer was no. And she said, only Walgreens. And you said, yes. But I have records from CVS and Brookshire's Pharmacy. Can you explain why? Okay. That's a credibility attack. Okay. Sometimes you can kill them with multiple credibility attacks. It doesn't have to be one silver bullet to a werewolf, but it can be multiple little attacks on credibility to where the court goes, yeah, I just can't believe him. There's too many credibility issues. Okay. Winning a credibility fight is the quintessential death by 1,000 cuts. Okay. Little credibility attacks. And that starts with you. Okay. Because by the time an attorney gets involved, the attorney is going to polish that story. The attorney is going to make it so that anything that was questionable before is now perfectly discussed. Because by the time we get the deposition, their deposition, that story has been perfected. What you have is the raw version. Okay. So you want that raw medical history. You want that raw personal history. Okay. Have you ever been convicted of a felony within the past 10 years? Now, we are limited in what we can ask in a deposition, but you're not in a recorded interview. You have any pending criminal charges?
Have you ever been arrested? Period.
Okay. Do you have any child support orders? Okay. You owe child support. Just ask. Okay. And again, like Annaline said, what if they go, why is this important? Mr. Jones, I'm sorry, I'm just working from a script. Somebody somewhere thought this was important, so I have to ask, and you're going to have to give me an answer. Okay? They don't know any better. They don't know that, most of them don't know if they can simply walk away from the recorded interview. You've got them there, go nuts. Okay? Now, once you've done this, circle back around. So, okay, Mr. Jones, I just want to clarify, from your accident, it was just it was just neck, shoulder, and head, right? Okay, now, I asked you a lot of questions. It took however long it took. Do you need to ask me any questions? Like, did you not understand any questions? Do you need to go back and revisit any of those answers? Okay, do you need me to clarify any questions? No, we're good. So that removed yet another piece from the table.